Hello students, this is the video lecture for chapter 11, all about intellectual property. I'm standing here near Lake Murray, sunset, it's almost sunset time. Or am I? Or am I? Perhaps this is artificial intelligence. I mean, after all, the San Diego sunset has to be one of the more photographed of the sunsets. So you feed all these images. Got it. You feed all these images into some supercomputer. What would sunset look like on this random day in July in Lake Murray? What would sunset look like? And then you could use AI for me too. Just feed in all the stuff I've done. I've made a lot of videos, put that in the computer. Bing, bang, boom. Maybe this is not real. Maybe this is artificial intelligence. And on a totally different note, maybe I should sell ads inside my videos. What do you think of that? I sell ads in the videos. I mean, students, you have to watch it, right? It's an assignment. You have to watch it. I could sell ads. Anyway, here you go. I'd like to do this lecture while I walk around the lake, but that's a bit much even for me. So just imagine during this lecture that I am walking around the lake or some AI virtual version of me. First, I want to start with this image of Marvin Gaye, very famous singer. Maybe some of y'all have heard of him, maybe through your parents or grandparents' record collection. And then Ed Sheeran, which I think more of y'all, I think it's a safe bet more of y'all will be familiar with Ed Sheeran. He has a song, Marvin Gaye's estate, he's now deceased, alleges that it is improperly borrowing too much from one of Marvin Gaye's songs. Now, Ed Sheeran, pretty sure he won this case. I'm pretty sure he won this case. But this issue illustrates the complexity of copyright. Copyright, I'll talk about that during this lecture, is a protection given to creators of different works of art, works of fiction, or other kind of works as well. That gives people control over what they create so that they can be financially compensated. That's the original goal. Now, when it comes to music, every few years there's, or maybe even every year, there's a big case about a famous song that's copying too much of another song. And I'll admit, this is not a music business class or music licensing class. I just know music is a very litigious issue. So if you're doing any kind of project, a student project, or when you get out in the world, inshallah, you're doing some sort of a media project yourself, just be super, super careful about using music because there's many, many rules. Rolling Stone songs are pretty much straight copies of blues, American blues songs that came before. So I don't understand what is a violation, what's not a violation. I don't get it. Copyright, which I already mentioned, is an exclusive legal right protecting intellectual creations from unauthorized use. Okay, trademark, which I'm not really going to talk about, but it is in the textbook. Trademark is a word, name, symbol, or design used to identify a company's goods and distinguish them from similar products or other what other companies are making. Okay, so I'm not going to talk about trademark. It is in the textbook. You should take a look at that. We have the Nike swoosh logo. See, swoosh. And then patents function in a similar way. I'm not going to talk about patents at all. But they cover inventions, basically new technologies, new types of software, new ways of doing things. Okay, patents function very, very similar in the way copyright functions. Now, the core principles behind intellectual property remain the same for whatever we're talking about. The idea is that whoever created that thing should be financially compensated. And the goal, follow me now on the logic. The goal is that if you allow people to get wealthy, to get rich for things that they create, they will create more things. And then society will have more positive things being created, whether that's works of art, works of fiction, sculptures, new inventions. So let's pay people so that they can get rich and then they will make more things. Now, there's also a provision that after a certain amount of time, these original protections are supposed to fade away. A copyright is supposed to fade away at a certain point so that anyone in society would be free to use that or borrow that or remix that. The idea is that it's going to make culture and society better if we have more good things being produced. Now, the way it has worked in reality is that if something is supposed to go into the public domain after X number of years, public domain means it has no protection. Something in the public domain anybody can use. You know, if say Mickey Mouse is supposed to go into the public domain because it was created, you know, practically 100 years ago, this little cartoon character, Disney and other corporations
I mean, it's not just Disney, it's everyone. They have ways of kind of loopholes of extending that so that I don't think Mickey Mouse, to me, I don't think is going to be in the public domain. They're going to find a way to protect that. Or, some song that was written X number of years ago. Whoever has the publishing rights to that song will find a way to extend it. With patents, what companies do is create a small refinement improvement over their original invention so that companies that own all these patents never ever let them go into public domain. They just keep kind of like putting a little bit on that invention and extending that. So that's that. And then you should be aware that, I assume y'all have figured this out already. Technology moves faster than the law. There's always new technologies coming out. And when copyright laws are written, they're written for the laws of the day, trying to guess the future, but they don't really guess the future very well. So some new way of distributing content, recording content, transmitting content will come out. And then this happens over and over again. Lawyers say, well, wait a minute, the laws that we wrote for the last thing don't apply to this thing. What does a copyright protect? Original works of authorship fixed in any tangible medium of expression. Once you put something down on paper, it is eligible for copyright protection. It doesn't have to be published. Now, here is one of these wiggle room phrases, substantially original. What is substantially original? That's a good question. I think we have the reasonable person argument here, but what is substantially original? There are different categories of works. You can read them here. These are in the notes as usual. Literary works, musical works, dramatic works, pantomimes and choreographic works. If I were to come up with some very clever, wicked TikTok dance to the newest Nicki Minaj song, wouldn't you love to see that? That could be eligible for copyright protection. Pictorial, graphic, sculptural work, motion pictures, and other audiovisual works, sound recordings, and architectural works. We'll talk about sound here in a minute. Ideas can't be copyrighted. You can't say, I have an idea. Writing down that idea on a piece of paper, if it's substantially original, could, but ideas themselves, history and facts cannot be copyrighted. What that means is there's a car crash on the 8. I live near campus. I live near Lake Murray, as I've already sort of revealed. That happened, right? Now, if I write a song about that accident on the 8 College Avenue exit, that song could be, but the thing itself, which means that news stories can be copyrighted because it's fixed in a particular form and the images and video that you've used to tell the story. The thing itself is not copyrighted. That's the distinction. Design features and clothing are eligible for copyright. 1972 is a big year. I already mentioned music and all the rules associated with music. I already mentioned unpublished works. If I write a manuscript, a novel, I don't have to publish it if I have it sitting, in some fixed, tangible form. You know what? I wonder if I saved it on my computer and never printed it out. Yeah, I guess that probably would be eligible. It seems like that would be if I could prove that I had created that at a certain time. Compilations. This is interesting. Say I come out with a book, an anthology that's collections of different essays that different people have written. Those individual essays can have copyright belonging to that individual author. But then my compilation itself, the way I've curated it and put it together, that could also be eligible. And then when it comes to new technology, HTML codes that underlie a website, that could be eligible. Or specific points of interest, something that has been entered into some kind of GPS database, that could be. You can't copyright the landscape itself because that's the landscape, but some information that has been put into a GPS database, that could be eligible. Page 529, we have a discussion of works for hire. If you have been hired by some company to do something, typically they'll make you sign a contract that they're going to own the copyright. And there are some questions. It's called work made for hire. There are some different facts that have to look at. Who owned the equipment? Where did the work take place? Who was determining the type of work to be done, the days and hours worked, whether there's a long-term relationship between the parties. So once you start doing employment, unless, maybe you've already started getting employment now, good for you. take a look at that. They're going to ask you to sign some type of contract. Who's going to own the copyright? If you're a freelancer, you should own the copyright. Um, and if you say you work for some online entity, which I expect most of y'all will, people who do online media, if they start republishing and reusing old material, if you have the copyright to it as the freelancer, they shouldn't really be doing that without giving you some type of compensation. And there are stipulations about transfer of copyright, like I can give it to someone else. It becomes almost like a property now that, I own the copyright to something property. And I just want to say, years ago when I was working, I was doing some work for, I think it was AOL, America Online, or Nickelodeon, something like that. And I had to sign a contract that the work that I was creating, it was just like trivia, sort of funny supplemental web content to go online to supplement classic TV shows, right? If people wanted more information or wanted something humorous. And I remember the contract I signed said that, Nickelodeon was going to own the copyright in any known universe. And when I signed that, this was like in the 90s, I thought, are they foreseeing colonies on Mars, and that maybe my Happy Days TV trivia gossip, whatever, is going to be used on a website in Mars? And then my wife, a couple years ago, politely explained to me that has nothing to do with, not universe in the sense of they're going to use my work elsewhere in the universe, but like whatever technologies were invented after 1996, 97, 98, whenever I did that work. Yeah, it was late 90s. Whatever technologies were invented, they're going to have the copyright to that. Anyway, I just thought that was funny. I think I'm signing my rights for my work to be used on Mars. That was not the case. The copyright holder has a right to do a great deal of things with their work: the right to publicly display it, the right to charge money for it, the right to create derivative works for it. There's a whole bunch of rights that come with copyright. The Supreme Court, this is important. That's why I put it in here. It's important. All right, it's important. All right, when VCRs came out, you could record a TV show on tape, actual physical tape. I know this sounds like archaic steampunk technology to y'all, okay? But you could actually record something on tape and then play it back. Well, movie studios, TV studios, including Disney, good old Disney, I love Disney, we're trying to sue the people for manufacturing this stuff, saying that you are violating our copyright. You're recording something and then you're playing it back. We, the copyright owners, have the right to publicly display our work, and that what you're doing is a violation of that. Well, the court said that recording something for your own use and then playing it back for your own use is not a violation of copyright. You are not publicly, this is like we get into like the specific legal minutia here. It's not a public display if I record Dallas, an old TV show, or I record a Padres game, or as they say that. If I watch it back myself, it's not public. Now you could say, well, other people come over, friends, neighbors come over. The courts have said, no, you could record something on your own and use it. But copyright holders do have the right to control how their work is distributed, especially when there's money involved. Okay. So I'll put the name of this case in the notes. I think it's Sony v. Universal or some version of that, something like that. Very, very famous Supreme Court case, which allowed VCRs to function. And then by precedent, we had digital video recorders as well. Now everything is available streaming on demand, but for those of you who do remember, you could legally record things and use it for your own use. Do you have to be human to have copyright protection? Yes, this is a famous case known as the monkey selfie case. I don't remember the specifics, but I got the gist of it. Researcher goes down someplace in the Amazon, South America, sets up a camera where you press a button, it takes a picture. He's trying to get photos of monkeys, and he doesn't want to be around because the monkeys are going to be inhibited when he's around. So he sets this camera up. This monkey, whatever his name is, figures out how it works, takes a nice selfie, like clearly understood how that thing worked. Press the button, smiles. Look, the thing smiles. This image is reproduced. PETA, I think People for the Ethical Treatment of Animals, or some other animal rights organization gets involved, sue, claiming that the reproduction of that work in a book wasn't fair because this creature, this monkey, didn't authorize that. The monkey has copyright because the monkey pressed the button. The judge said, no, you have to be human. You have to be human. And The reason it's important today is I put into one of these AI art generators. I wanted a robot DJ, and I'm really disappointed with what it gave me. I mean, that's a robot DJ, but that doesn't look very fun, cool, funky, whatever. Just looks like a stupid robot DJ. Yeah, or maybe I said cyborg DJ. Anyway, okay, with artificial intelligence is going faster and faster. It will have grown leaps and bounds by the time I post this video, and I'm using it in subsequent semesters, let's say. But you get the idea that like it can do things that are like a human can't tell that that was created by AI. Courts right now, as of this summer 2023, said that no, AI doesn't get any copyright protection, and it would go to the people who own the computer, put in the program, some human. It can't just, the things aren't sentient and function on their own. Okay. But it's a very interesting challenge, and I think an ethical challenge that we will all be dealing with for years to come. Now I'm going to play a snippet right here. I'm going to come out of the lecture and play this song. Is known as Fake Drake. I assume many of y'all know what I'm talking about. Some DJ feeds information into a computer and creates a song that sounds like Drake, right? And it wasn't. But anyway, I'm just going to play a snippet of it in case you ever heard it, in case you haven't heard it, just to show that like we're getting, or we haven't gotten to the point where it's difficult for humans to distinguish what was created by other humans and what is created by artificial intelligence. And this debate, again, this is the summer 2023, is very central to what's going on in Hollywood with the actors and writers striking right now. Actors in particular don't want their image used. The studios had a deal where they would say, hey, we're going to record you for a day, get your image and likeness, have you move around, probably do a couple different things. We'll record that. Then we can make, virtual background actors and anything we want for whatever we want. We don't have to pay these virtual background actors. And you, the human whose image and likeness we've captured, will pay you for one day's worth of work, whatever your union rate is. That doesn't seem fair. But anyway, just to kind of put that out there, that summer 2023, this is the concern, that this is the future we are going to. Anyway, enough of my babbling. Here we go, Fake Drake.
The flex, bumping Justin Bieber, the flavor and left, she know what she need.
WTF is an NFT. Okay, I'm not that dumb, all right? I kind of know what a non-fungible token is, but I admit I still don't really understand 100%, okay? And the point that I want to stress here, and it's in the textbook, is that big question mark. No one really understands what's going on here, especially not in terms of copyright. If I buy an NFT, which is some digital image that's supposed to be unique, I'm not buying the copyright to that thing. Say I buy a digital version of the Mona Lisa, for example. I'm not now the copyright owner of the Mona Lisa. I don't even think I'm the copyright owner of the digital version of the Mona Lisa that I've got. I think I've just bought the metadata that goes with the NFT. And then if I want to then use that digital image of the Mona Lisa, say on a coffee cup or a business card or something like that, I may not have the copyright to do that. Okay. So that's a big fancy way of saying, I don't know what's going on. Big question mark. If you buy an NFT, I don't think you should. There's probably better ways to invest your money, get your student loans paid off. That's what I'm saying. But if you buy an NFT and want to start using that yourself, talk to a lawyer to see if you can actually do that. I don't even know what rights you're getting. I really don't even know what rights you're getting when you buy an NFT. So just question mark, NFT. Arsenault says WTF is an NFT. Okay. All right. Now, we've already established that copyright protection gives you the rights to control the way your work is distributed, sold, et cetera, but you can use portions of people's copyrighted work under what's called fair use. Okay, that is the broad legal category, fair use. And to determine if something is fair use or falls within fair use, courts will look at the purpose and character of the use. Educational use is usually considered good. If I take 20-second clip of The Office and use it in a lecture, which I have been known to do, that's okay, because I'm an educator. I'm not really making money per se from it. I mean, I get paid to be an educator, but I'm not like charging people admission for my lectures. There's an idea. So that's okay, educational, non-commercial use. They'll also look at the nature of the copyrighted work, certain things. If it's a documentary about a news event, that might be a little bit more acceptable to take a portion of it because you're informing people about some news event. Now, you can't copy 90% of something. Can you copy 30% of something, 25% of something, 29% of something? This is the courts have to determine, but the less you use, you're generally okay. If you use, a very, very small amount, it's generally okay. I could not come in and show, 90% of, say, a film like The Post, which is about, depending on paper's case, that's probably not okay. A little bit of it is probably okay. And then the economic impact of the use. If my use of some copyrighted material destroys the market for that other thing, then that's probably not okay. I think there was a case where someone came out with like a Harry Potter guidebook, like, someone read all the Harry Potter books. There's a whole bunch of them, right? And then came out with a guidebook about, a guide to the lore and the mythology and the different creatures, et cetera, kind of like a handbook, an encyclopedia handbook. They were trying to claim fair use. That's not okay because whoever has the copyright, J.K. Rowling, I guess, and maybe some big studio, they presumably could have come out with their own such book. It's not very creative or unique of an idea. So my almost like fan fiction, my fan fiction handbook to the Harry Potter universe is going to take away, if it were sold and became big, it would take away the market for that other company to do that. So that would not be okay. So these are the different things that courts will evaluate, trying to determine if something is fair use or not. Who's calling me? Hey man, you got me right in the middle of recording a lecture. All right, yes, these are the things that the courts will evaluate to determine if something is fair use or not. Section 512 and DMC safe harbor protections, the shields ISP from infringement claims. And specifically, I'm looking at the textbook now, page 547. If an internet service provider posts something, say like a video, say I've taken a video of The Office, too long of a video, more than 20 seconds, and posted it, I might be subject to some type of penalty for copyright infringement. If whoever owns Warner Brothers or whoever owns the copyright to The Office contacts, say, YouTube or some other internet service company, and that company takes it down, that company is now not responsible. They're calling it a notice and takedown. So that gives some type of safe harbor protection. There is something called red flag knowledge. You should take a look at that. That is something that's so extreme, person hosting that video should have known that what they were doing is wrong. So take a look at that section of the textbook. And again, to circle back to the beginning of the lecture, this is yet another example of the courts trying to keep abreast of technological changes. And I'm not going to talk about trademark, but this case, very fascinating case, extremely fascinating case, is talked about at length in the textbook, and I encourage you all to take a look at it. Mattel v. Tam. We have an Asian American rock group who use the name The Slants, which many people in the past have thought to be a pejorative negative term for Asian Americans. It is a pretty ugly term, I admit. It's a pretty ugly term, but that's the name of the band. That is the name of the band, okay? They tried to get trademark protection for their name, originally denied. And it relates to something called the Lanham Act. You should be roughly familiar, at least know what the Lanham Act is. And in this case, it had to do with disparaging trademarks. You can't get a trademark for a disparaging name. However, the football team from Washington, D.C. had a pretty ugly, disparaging name. I mean, I think we can all agree. Whatever your feelings are about the use of indigenous people's names for sporting teams, that football team in DC, that was pretty extreme to have that name. Pretty extreme. Okay, anyway, that's it. Wrapping up. And I hope you enjoyed the walk.